Listen, I want you to picture something real, not a hypothetical, not a story somebody made up on the internet. A real American retiree, a real kitchen table, a real mistake, and a very real financial disaster. It's Tuesday, March 17th, 2026, 7:14 in the morning, Sun City, Arizona. Richard Turner is 71 years old, retired postal worker, married to the same woman for 43 years, a man who spent his entire life doing exactly what he was told to do. Work hard, save money, stay out of debt, plan for the future. The coffee is brewing, the Arizona sun is beginning to push through the kitchen window, and sitting beside Richard is a faded photograph from 1989, a road trip through Colorado. Richard and Martha standing beside an old pickup truck, both smiling, both younger, both convinced that if they worked hard enough, retirement would finally be the reward. Richard still keeps that picture on the table every morning, because it reminds him why he sacrificed, why he skipped vacations, why he worked overtime, why he contributed to every retirement account he could. Richard did everything right. He paid off his house early. He contributed to his IRA for decades. He updated his will after retirement. He avoided unnecessary debt. He even met with an estate planning attorney after turning 65. Everything looked organized. Everything looked protected. Everything looked safe. Then one phone call changed everything. The call came from an attorney handling the estate of one of Richard's longtime friends, a man named Robert. Robert had recently passed away. His family believed everything was in order. There was a will. There was an estate plan. There were clear instructions. Simple, straightforward, or so they thought. Then the attorney discovered something buried in paperwork that nobody had reviewed for years. An old beneficiary designation, a single form, one forgotten document. That one form redirected more than $412,000 away from the people Robert intended to receive it. The will said one thing, the beneficiary form said another, and the beneficiary form won. Just like that, years of planning, years of assumptions, years of believing everything was protected. Gone. Richard sat frozen at the kitchen table. The coffee had gone cold. The room suddenly felt smaller, because one thought entered his mind, a terrifying thought. What if I made the same mistake? What if my beneficiary forms haven't been updated? What if my retirement accounts don't match my will? What if my family is heading toward the exact same disaster? Richard immediately began digging through old account paperwork, IRA statements, insurance documents, retirement records, and then he found it. A beneficiary designation that hadn't been reviewed in years. Years! His hands started shaking, not because he knew there was a problem, but because he suddenly realized he had never checked. Not once. And here's what should scare you. Richard is not unusual. He's not careless. He's not irresponsible. He's not financially illiterate. He's exactly the kind of person retirement planners love to describe as prepared. And yet millions of Americans are walking around with retirement accounts, life insurance policies, and beneficiary forms they haven't reviewed in years. Many believe their will controls everything. Many believe their trust controls everything. Many believe their family is protected. In many cases, that belief is completely wrong, because there is a hidden inheritance trap buried inside the retirement system, a trap that can override your wishes, a trap that can bypass your will, a trap that can redirect assets in ways you never intended. And most retirees don't discover it until somebody dies. By then, it's usually too late. This is the hidden inheritance trap. And today, I'm going to expose exactly how it works before it affects your family. Welcome back to the archive. I am the retirement insurgent. And today, we're tearing the roof off one of the most dangerous estate planning mistakes hiding in plain sight. Now, before we go 1 inch further, I need you to do something. Smash the like button right now. I am not asking, I am telling. Because videos like this don't usually get pushed to the people who need them most. The people who need to hear this are retirees, widows, veterans, middle-class families, people who spent decades building a nest egg, people who think their estate plan is finished, people who think their will solves everything. And unfortunately, many of those people never see this information until after the damage is done. Your like helps break through that wall. It helps another retiree discover a mistake before it becomes a family disaster. So hit the button right now. And if you're new here, subscribe and turn on notifications. Join the archive, because this channel exists for one reason: to expose the retirement traps nobody talks about until it's too late. Every week we break down the rules, loopholes, penalties, tax surprises, and estate planning mistakes that can affect ordinary American families. Not Wall Street, not billionaires, regular people. People like you, people like Richard. And before the lawyers start sending angry emails, let me say something important. This video is for educational purposes only. It is not legal advice. It is not financial advice. Estate planning laws vary by state, Beneficiary rules can differ depending on the account type, your marital status, and where you live. Always consult a qualified estate planning attorney or financial professional regarding your own situation. Good. Now let's continue. Because what you're about to learn is something many retirees never hear. Not from their bank, not from their insurance company, not from the financial industry, and sometimes not even from the attorney who prepared their will. By the end of this video, you're going to understand three things. First, why beneficiary designations often override wills and trusts. Second, how a simple paperwork mistake can completely change where your money goes after you're gone. And third, the practical steps retirees can take to make sure their wishes and their paperwork actually match. Because the truth is this, the hidden inheritance trap isn't complicated. That's what makes it so dangerous. The danger isn't complexity. The danger is assumption. People assume the documents are updated. People assume everything works together. People assume somebody checked, and sometimes nobody did. Let's go to work. Most retirees believe something that sounds completely reasonable. If it's written in my will, that's where my money goes. Simple, logical, wrong, at least in many cases. And that's where the hidden inheritance trap begins. Because your will and your beneficiary forms are not the same thing. They do not operate under the same rules. And they do not always point in the same direction. This is where families get blindsided. A retiree spends thousands creating a will, maybe even creates a trust. The documents are signed. The family feels protected. Then years later, someone passes away. And suddenly the family discovers another set of instructions existed all along. Instructions hidden inside retirement accounts, life insurance policies, annuities, employer retirement plans. And those instructions can sometimes take priority over everything else. Look at the dirty legal trick they use. When you open an IRA, 401k, life insurance policy, or certain investment accounts, you are usually asked to name a beneficiary. That beneficiary designation becomes a contractual instruction attached directly to the account. When the owner dies, the financial institution often follows the beneficiary form on file, not the will, not what family members expected, not what someone verbally promised. The form, the paperwork, the beneficiary designation. That's why outdated forms create so many problems. A retirement account opened 20 years ago may still contain instructions written 20 years ago, even if your entire life has changed since then. Marriage, divorce, children, grandchildren, a second marriage, a death in the family. The account doesn't know any of that. The form only knows what was written on it, and unless somebody updates it, the old instructions may remain in place. After studying estate settlement cases, probate procedures, and beneficiary disputes across multiple states, the pattern is unmistakable. The families hurt most by this trap are usually the families who thought everything was already handled. That is the irony. The victims are often the planners, not the procrastinators, the planners. Now let me show you how fast the damage can happen. Let me do the math live so it lands. Susan Walker is 69 years old. She lives in Florida. Susan has an IRA worth $380,000, a life insurance policy worth $150,000, and savings accounts totaling $90,000. Years ago, after a divorce, Susan intended to update all her beneficiary forms. She updated some, but not all. One old beneficiary designation remained attached to both the IRA and the insurance policy. She forgot about it. Her attorney never asked. Her financial institution never contacted her. Years passed. Now look at the dirty math here. IRA value, $380,000. Life insurance value, $150,000. Combined value, $530,000. Meanwhile, her savings account contains $90,000. Susan's will leaves everything equally to her children, but the beneficiary forms still point somewhere else. When Susan passes away, the IRA follows the beneficiary form. The life insurance follows the beneficiary form. Only the savings account follows the will. Potential assets redirected away from her intended heirs? $530,000. Not $5,300, not $53,000, $530,000. This should make you absolutely furious, because nobody hacked the account, nobody committed fraud, nobody stole anything. The paperwork simply followed the instructions already on file. And here's the part that should put smoke out of your ears. Many retirees don't even know where all of their beneficiary forms are located. Some accounts were opened decades ago. Some were transferred between institutions. Some were inherited. Some were forgotten, yet every one of them could potentially carry instructions that no longer reflect your wishes. This should make you absolutely furious, because families often discover the problem after the funeral, after the estate process begins, after emotions are already running high, and by that point, options can be limited. But here is where the real horror starts. Because the beneficiary trap isn't just about old paperwork. It's about understanding why the system works this way in the first place. And once you understand that, you'll see why so many families get caught completely off guard. Now let's answer the question most people never ask. Who designed this? Who decided that a single beneficiary form could sometimes outweigh years of estate planning? Who built a system where families can spend thousands on wills and trusts, only to discover another document was controlling the outcome the entire time? The answer isn't one person. It's a collection of laws, regulations, retirement rules, and contractual systems that evolved over decades. And while many of these rules were created for administrative efficiency, they can create serious consequences for families who don't understand them. The system is designed to follow contracts first, not intentions, not conversations, not promises made around the dinner table, contracts. Financial institutions need a clear instruction when an account owner dies. Beneficiary forms provide that instruction. From an administrative perspective, it makes processing easier. From a family perspective, it can create a nightmare. Who benefits? Financial institutions benefit because beneficiary transfers often avoid lengthy probate procedures. Insurance companies benefit because payouts can be processed according to contractual instructions. Administrative systems benefit because they reduce uncertainty and disputes over account ownership. And who loses? The retiree who assumed everything was already handled. The surviving spouse who discovers an outdated designation. The children who learn that a parent's wishes and paperwork were not the same thing. This should make you absolutely furious, because the danger isn't hidden in complicated legal language. The danger is hidden in assumptions. Assumptions that somebody reviewed the forms. Assumptions that the will automatically controls everything. Assumptions that retirement accounts somehow update themselves when life changes. They don't. And here's where things become even more complicated. 3 states, 3 completely different realities. Let's start with Florida. Florida has certain laws that may revoke some beneficiary designations after divorce under specific circumstances. That sounds protective, and sometimes it is. But not every account falls under the same rules. Not every situation produces the same outcome, which means retirees can still face surprises if paperwork isn't reviewed. Now look at Pennsylvania. Pennsylvania often treats beneficiary designations differently depending on the type of account involved. Retirement accounts, insurance contracts, investment accounts. Each may operate under slightly different legal frameworks. The result? Families can face very different outcomes depending on where the assets are held. Now let's move to Nevada. Nevada is known for strong contract enforcement principles. In many situations, beneficiary forms remain extremely powerful. If outdated instructions remain on file, those instructions may continue to carry significant weight. 3 states, 3 completely different realities. The same retiree, the same family, the same retirement account. Wildly different outcomes depending on location and account structure. And that's exactly why relying on assumptions is so dangerous. Because what works for your neighbor may not work for you. What happened to your brother in another state may not happen in yours. What protected one family may not protect another. Oh, friends, it gets so much worse. Because the people most likely to fall into this trap are often the people who believe they're already protected. The organized ones, the responsible ones, the planners. Let me ask you something. When was the last time you reviewed every beneficiary form attached to every retirement account, insurance policy, and investment account you own? Not your will, not your trust, the actual beneficiary forms. Was it last year? 5 years ago? 10 years ago? Or have you never reviewed them at all? Tell me in the comments right now. Have you checked your beneficiary designations within the last 3 years? I read every comment. Your experience may help another family avoid a costly mistake. And now I need you to do something important. Pause this video. Open your phone. Think of one family member, one sibling, one friend, one retired neighbor, someone who believes their will controls everything. Send them this video. Not tomorrow, today. Because one 5-minute conversation today could prevent years of confusion, conflict, and financial surprises later. You are not simply sharing a video. You are delivering a warning that many families never receive until it's too late. And now it's time for the part that matters most. The playbook, the protection plan, the steps retirees can take to make sure their wishes and their paperwork finally point in the same direction. Now let me give you some good news. This trap is dangerous, but it is also preventable. Most inheritance disasters don't happen because families lacked money. They happen because paperwork and intentions stopped matching. That's the entire problem, and fortunately, that's also where the solution begins. Save this video right now. This is your survival manual. Because when your family is sitting in an attorney's office someday, you want these steps completed long before that meeting ever happens, not after, before. Now let's get to the strategy. the actual playbook. Strategy number 1, the annual beneficiary audit. Most retirees review their investments. Some review their taxes. Very few review their beneficiary forms. That is a mistake. At least once every year, schedule what I call a beneficiary audit. Pull out every retirement account, every IRA, every 401k, every annuity, every life insurance policy, every brokerage account that contains a transfer on death designation. Then compare every beneficiary listed on those accounts to your current wishes. Not what you wanted 10 years ago, not what you intended after your divorce, not what made sense before grandchildren arrived. Your wishes today. Because life changes, families change, relationships change, and beneficiary forms don't magically update themselves. Think of it like this. Your retirement plan is a fleet of airplanes. Every beneficiary form is a flight plan. If one airplane is flying to the wrong destination, it doesn't matter how good the rest of the fleet looks. That plane is still landing in the wrong city. The same thing happens with inheritance planning. One wrong beneficiary form can send assets somewhere you never intended. Strategy number 2, estate alignment review. This is where most people discover hidden problems. Your will, your trust, your beneficiary forms, your account ownership structure. All 4 should be telling the same story. Yet many retirees have documents created years apart. The will says one thing, the trust says another. The beneficiary form says something completely different, and nobody notices until someone dies. When you conduct an estate alignment review, you compare every document side by side. The goal is simple. Everything should point in the same direction. Every instruction, every designation, every account, every document. One coordinated plan, not 3 competing plans. After studying estate settlement disputes, probate filings, and beneficiary conflicts across multiple states, one pattern is unmistakable. The families with the fewest inheritance problems are usually the families whose documents were reviewed together rather than separately. That isn't a coincidence. That's preparation. Strategy number 3, the life event trigger system. Most retirees update documents based on time. The smarter approach is updating documents based on events. Certain life events should automatically trigger a complete review. Marriage, divorce, death of a spouse, birth of a grandchild, a major inheritance, a relocation to another state, retirement itself. Each of these events can dramatically change your estate plan. Yet many retirees continue using beneficiary designations created before those events occurred. That's how traps develop. One outdated form, one forgotten account, one missed update, and suddenly years of planning can be undermined. The goal is not perfection. The goal is consistency, because consistency protects families. Consistency prevents confusion. Consistency helps ensure your wishes and your paperwork remain aligned. And now I want to show you something powerful. 2 families, the same assets, the same circumstances, the same inheritance opportunity, but 2 completely different outcomes. And the difference comes down to one thing, preparation. Let me show you 2 families, same state, same assets, same retirement lifestyle, same inheritance goals, 2 completely different outcomes. Watch what happens. Meet David Harris, 72 years old, retired electrician, lives in Arizona. David has spent decades building a solid financial foundation. His assets include IRA, $500,000, life insurance, $250,000, brokerage account, $180,000, total family legacy, $930,000. Now let's look at Type A. Type A, no planning. David creates a will. He assumes everything is covered. He believes his family is protected, but he never reviews the beneficiary forms attached to his accounts. Years pass. Nothing happens. Everything appears fine. Then David unexpectedly passes away. His family begins settling the estate. The will clearly states who should receive the assets. The family feels confident. Then the paperwork review begins. The IRA still names an outdated beneficiary. The life insurance policy still contains instructions from years earlier. The brokerage account points somewhere else. The estate attorney delivers the bad news. Some assets follow the will. Some assets follow beneficiary designations. Some assets go places David never intended. Family confusion begins. Arguments begin. Legal consultations begin. Money starts disappearing into administrative costs and delays. The emotional damage is even worse, because everyone believes they know what David wanted. But the paperwork tells a different story. Now let's look at Type B. Type B, the insurgent plan. Same David, same assets, same retirement, same family. But 5 years earlier, David conducts a complete beneficiary audit. Every account, every designation, every document, everything gets reviewed. everything gets aligned. The will matches the trust matches the beneficiary forms. The beneficiary forms match David's actual wishes. When David passes away, the process is entirely different. The attorney reviews the documents, everything matches, no surprises, no conflicting instructions, no outdated designations, no family disputes, no inheritance confusion. Assets move according to the plan David created. The family focuses on healing instead of fighting. The legacy arrives where it was intended to go. The difference? Not a different investment, not a different account, not a different amount of money, different paperwork, different preparation, different outcome. Potentially hundreds of thousands of dollars directed exactly where David intended. Same family, same assets, same retirement. Different legal structure, different preparation. Completely different outcome. That is the entire game. Here is what you are going to do tonight. Not next week, not next month, not after the holidays. Tonight. Because the hidden inheritance trap grows stronger every year you ignore it. Step 1. Pull out every retirement account statement you own. IRAs, 401ks, brokerage accounts, annuities, life insurance policies, everything. Create a complete list. You cannot protect assets you cannot locate. Step 2. Contact each institution and request confirmation of your current beneficiary designations. Do not assume. Verify. The most expensive word in retirement planning is often assume. Step 3. Compare every beneficiary designation against your will and trust. Look for conflicts. Look for inconsistencies. Look for names that no longer belong there. Look for instructions that no longer reflect your wishes. Step 4. Schedule an estate planning review. Not because something is wrong, because you want to confirm everything is right. A 1-hour review today can prevent years of family confusion later. The clock is already running. Life changes every year. Families change every year. Relationships change every year. Your documents should change when necessary too. Tell me in the comments which step you're starting first. And tell me your state. The archive learns from each other. And if this video helped you understand something you didn't know yesterday, share it with someone you care about. Not tomorrow, today. Because inheritance mistakes don't just affect the person who made them, they affect everyone left behind. You can be the retiree who assumes everything is fine, or you can be the retiree who verifies, the retiree who reviews, the retiree who protects their family before a problem ever appears. The choice is yours, because the hidden inheritance trap doesn't target reckless people. It targets good people, responsible people. People who spent decades doing everything right. People who believed they were already protected. And that is exactly why awareness matters. That is exactly why preparation matters. And that is exactly why you need to act before your family is forced to deal with the consequences. If you found value in today's video, smash that like button one more time on your way out. Help more retirees discover this information before it becomes a costly mistake. Subscribe, turn on notifications, join the archive, because retirement isn't just about building wealth, it's about protecting it. And in our next video, we're exposing one of the most overlooked retirement tax surprises in America, the widow's tax penalty, and why thousands of surviving spouses see their tax bill jump after losing a partner. You do not want to miss that one. Until then, protect your family, protect your legacy, protect what you've spent a lifetime building. I am the retirement insurgent. This was the archive. The trap was built for the retiree who doesn't know it exists. Now you know. Act accordingly.